Hi, good morning. Welcome to PASR. Today we have Jessica Fisher-Greene from Walters and Galloway today, and she will be discussing estate recovery mixed with Medicaid and Estate Administration. So we want to thank you for joining us, Jessica, and go ahead with your presentation when you're ready. Thank you.
Good morning, everyone. I appreciate you joining us. And thankfully, it's virtual, so we do not have to go out in the very cold weather today. So, like Nancy said, we're going to get into estate recovery and Medicaid. So, a little agenda here today, talking just generally about Medicaid, which in Pennsylvania, we call that medical assistance. Give you a little background on the estate recovery program, how it came about, really where it's coming from and where those assets that they're recovering are going. Talk about probate because that plays a huge part in this whole process with estate recovery and who is really affected by the estate recovery program. And we're going to talk a little bit about how maybe we can avoid some of these pitfalls and for the probate process. And then we'll get into a little bit more describing that. We'll talk a little bit about gifting and then just generally like some common questions I get, is my home at risk? And I'll get into some examples. And then I think Nancy had already mentioned, but feel free if you have a question, you can put it in the chat and then I'll definitely be answering questions at the end as well. So medical assistance, like I said, Pennsylvania, that is the term that we use. Each state has their own term for this program, but it is a federally run program. So it's Medicaid is the federal program that has kind of the base rules, and then it's run down through each state. So each state cannot make the program more restrictive than it is federally, but they could make the rules a little more lenient in some circumstances. So in order to qualify for medical assistance, first the person must have a medical need. So that means that they have to require skilled nursing level of care. So this is something that their doctor can fill out on. There's a certain form that goes with the medical assistance program. And the doctor must mark the box that's labeled NFCE. So that means nursing facility clinically eligible. So that's really step one. When we're looking at applying for medical assistance, the person must have that medical need. So that means that if someone is, say, in a personal care home or just a memory care home or independent living, they are not going to qualify for Medicaid because you cannot get skilled nursing in those independent living facilities or personal care or memory care homes. So you really have to be looking for that highest level of care. Then we look at, because this is what we call a means-based program, we have to look at the income and the assets of the individual. Now, if someone is applying for Medicaid in the nursing home, so they're actually placed in the facility, the income requirements are different than if they are applying for care in their home. So if they are applying for the Medicaid waiver program, which is the program that pays caregivers to come into someone's home and help with the skilled nursing there, the person's income cannot be greater than $2,901 a month. If the person is in a facility, so they're actually at the nursing home location, their income just must be less than the cost of care per month. So most people in retirement don't have that high of income. So typically the average cost of care in a nursing home in this area is between $12,000 and $15,000 a month. I don't know about you all, but I do not know a lot of people who have $15,000 a month in their retirement as their income. So it's a lot easier to qualify under the income requirement when you are in the facility than it is when you are staying at home. So on that same kind of wavelength, when we look at the assets, the amount of assets that the person who is applying for Medicaid can keep is determined based off of what their income level is. So if their income is less than that $2,901 a month amount, and these are gross amounts, this is not the net amount that is hitting your bank account. So if it's less than that, the person is allowed to have $8,000 in assets and qualify for Medicaid. If their income is greater than the $2,901 per month, then they are only allowed to have $2,400 in assets in order to qualify. Now, there are different rules if someone is married. So what happens with that is that the spouse, in that case, is called a community spouse. The community spouse would be able to keep half of the assets up to a maximum of $157,920. So what that means is if a couple has $500,000 in countable assets, the community spouse cannot keep $250,000, but can only keep that maximum amount of $157,920. On the same end of it, there is a minimum. So let's say that the couple's total assets are $32,000. Okay. They're not going to say that the community spouse can only keep half of them. They're going to say that the community spouse gets to keep the $31,584. So we're not going to cut it in half when it's going to cut into their minimum. So a little background on estate recovery. So as I was mentioning earlier with these programs, so estate recovery was originally established under federal law, and then it's funneled down to the state. And so the state has to enforce this. And so they have to recover any medical assistance costs that they paid for someone while that person was alive. They're going to recover it from that person's estate. And they can only recover the amount that they paid during that person's life. So they actually keep track of every single penny that they paid for someone on medical assistance. And I don't know if anyone is familiar with these, but what happens is they get what's called a statement of claim. So in some cases, if the person has been on Medicaid for quite a few years, which is usually the case, these statement of claims can be a huge packet. And they really, you can go through and see they paid for every single thing. So, down to the Depends, different medications, shampoo, all the different things that they paid for are going to be listed, all the care, everything in this packet. And then at the end, it's going to say what the total is that Medicaid paid for. And they are trying to recover this amount. So when they're recovering, they have it broken down into two different categories. So any of the medical assistance paid within 6 months of the person passing, that's going to be at a different category than anything that was beyond the 6 months. And then all money that estate recovery collects through this repayment program is going to go back into the program to pay for future applicants' care.
Oh, there you are. Yeah. Can you say hello?
Hello?
Hi, did you have a question?
This is Bob Marco. Can you hear him?
Yeah, I can hear him.
Okay, great. We're good.
Oh, okay. If you want to go ahead and mute yourself just so we don't get any feedback on that, that would be great. Thank you so much for attending.
Okay.
So for the probate then, probably most of you on the call today have heard of this term probate, but what is probate really? So that is the process that someone goes through after a person has passed away. So they're going to the Register of Wills for the county where the person resided during their life, and they're going to submit the will to that Register of Wills. And when they're submitting it to them, they are deciding if the will is valid. And they're entering it into this formal process that starts a timeline of events. So that is the probate process. So it's going to create this timeline where notices are going to have to be given, court filings, publications, inheritance tax returns, starting a whole process. Now, if someone does not have a will, but they still have probate property, so in either case, we're only going through this process of probate if they have probate property. So that is something that someone owns in their name alone that does not have a beneficiary on it. A really good example that typically you do not see a beneficiary on this asset would be real estate. So if you own your house in your name alone, when you pass away, in order for us to get that property to the next line, whether the people are named in your will or we're following Pennsylvania law because you do not have a will, we have to enter it into this probate process so that someone can be formally appointed. So the person who is formally appointed is either they're named in your will, so they're called the personal representative, or the executor or executrix. Or if you do not have a will, then Pennsylvania is going to decide who is in charge based off of who's left that's alive that's related to you. And that person is going to be called your administrator or administratrix. Now, this is all very important when it comes to estate recovery, because the estate recovery program only allows the state to get repaid from the Medicaid recipient's probate estate. So if the Medicaid recipient owned anything when they passed away that was in their name alone, that did not have a beneficiary on it, that is what estate recovery can make a claim against. So very important to keep that in mind. So who is affected by this program? There are so many different types of Medicaid. There are some for younger people, there are some for older people, for people with disabilities, all different categories. But the estate recovery program is only applying to people who are age 55 and older and who received Medicaid for care in a nursing home, or that Medicaid waiver program. Like I said, they're coming into your home and you still need that skilled nursing. So that's called the home and community-based services. And then it's any prescription drugs or hospital stays, anything that happened in the nursing home that Medicaid paid for is also going to fall into this category. But when does the estate recovery actually occur? When are they going to try to make that claim to get paid back? It's only after the person passes away. So this is something that sometimes people get confused about, because sometimes they might get a statement of claim while they're alive, and it's just Medicaid saying, this is what we've paid for so far, but they're not expecting to be actually repaid until the person passes away. There are some circumstances where someone is on Medicaid and they're in the facility, but they still owned their home. And maybe then they sell their house. So in order for them to maintain their eligibility for Medicaid, they could repay their estate recovery bill while they are alive, just so they can stay on Medicaid and not have a disruption of the services. So let's talk a little bit about how we can avoid that estate recovery. So the big thing is that if you are in the nursing home or you're getting these services at home and you're on Medicaid, you want to think about, how can I avoid probate? Now, you have to be extremely careful about all of this. This is not a try it yourself, do it at home kind of thing, because if someone is on Medicaid or they are about to apply for Medicaid, you have to be very careful about adding anyone as a joint owner or doing these types of things, because you do not want it to be considered a gift. And I'm going to talk about gifting later, but I just wanted to bring it up now when we're talking about avoiding probate. So some ways to avoid probate: if everything you have is jointly owned with another person. If you added beneficiaries to all of your accounts, so like a pay on death or a transfer on death, or maybe it's an account that already has beneficiary designations, like life insurance, just making sure that those beneficiary designations are up to date and that the person you have named as getting these assets is actually alive and well. And then you can also think about transferring these assets to a trust. So there are multiple types of trusts. There's revocable and irrevocable. Either one is going to avoid probate. It's just that the irrevocable trust will also, if the assets are in there for at least 5 years, will also protect the assets from the Medicaid and nursing home program to begin with. Now, a big thing to think about here: avoiding probate does not mean that you will avoid the Pennsylvania inheritance tax. So just to be aware of that, the only way to avoid it is if the surviving owner or beneficiary is an exempt party. So exempt parties are spouses, children under age 21, charitable organizations. Those would be the exempt parties. So they're all at a 0% inheritance tax. But otherwise, there are some assets that just generally avoid inheritance tax. Life insurance is one of them, or if you have it in certain types of trusts, at least 1 year before you would pass away. So some pitfalls for trying to avoid probate. Like I said, you could be trying to avoid probate. You might make a gift, but that could then negatively impact your eligibility for Medicaid. But some other things to think about beyond that. Let's say that you put all of your assets in joint ownership with your child, but your child died before you. Now you have to pay Pennsylvania inheritance tax on your own money. Your child's share of the account could then be susceptible to their own creditor. So if they're getting sued, they got in an accident, now your accounts could be vulnerable to those issues. Or your child is getting a divorce, your accounts could be part of that. Another big one here is, let's say that you have 3 children and your goal is to leave everything equally to all 3 of your children. But you named one child as the joint owner on your account. That one surviving child becomes the sole owner of the account, and you do not get to that guarantee that they're going to share those assets with all the other kids. And then there could be some capital gains to think about. So when you purchased your home, that had your purchase price in it. But when you pass away, hopefully the house is worth a lot more money at that time. And if you had added your child as an owner while you were living, they're going to take your original purchase price in the property as now their value. So if they go to sell it, they could have capital gains. Whereas if they had just inherited it from you, they would not have had those. So just some heavy things to think about there, that you really have to weigh out the pros and cons here of, what is the best for your specific situation. So we're going to switch gears into the estate recovery process. So like I said, after a Medicaid recipient passes away, we have to give notice to the Department of Human Services. So we call it third-party liability program. It's through the state of Pennsylvania. And the person who is going to be giving that notice, we typically call that person the personal representative. So if it's the person named in your will, so their executor, executrix, or if you didn't have a will, but you do have this probate property, then they're going to be your administrator or administratrix. And it's just generally someone who is representing your interest after you have passed away. They're going to send in this notice to the state. So they're required to do that. If you have a probate estate and you're over age 55, we are required to send that notice. Even if we don't think that you were on Medicaid, we are still required to send that notice as part of the estate administration process. So then we're going to request this statement of claim. So that is that long stack of papers that I was mentioning earlier that has all the details of everything that was paid for by Medicaid. And in there, we have to put in this specific request, and it has to have the exact language that they are looking for. So it has to provide, the Social Security number, the Medicaid number for the person, when they passed away, who is the contact person, and how much do we think the probate estate is worth. These are all things that they have to have in the notice. It's really important to make sure that you send in a complete notice, because Medicaid only has 45 days to respond to this notice. So if you send them a complete notice and they do not respond within 45 days, they have waived their right to make a claim on the estate. But if your statement of claim request was not complete, you were missing something, and they don't act within the 45 days, they have not waived it because you did not submit the right request. So we're going to talk a little bit about when we're administering an estate, how the debts of the estate get paid and what's the order on that. So you're administering an estate and you get this big statement of claim from Medicaid. So first off, Medicaid, that statement of claim is not in the first category. The first category is our cost of administration. So that would be like if you had a house you're administering it for, and you had, utility bills that you had to pay for the house, attorney's fees, accountant's fees, probate costs, all those things would fall into just general cost of administration. And that's at the first level. Then at the second level, there's something called a family exemption. So this would be if a family member, so a spouse or child, lived with the decedent, the person who passed away, and they then get to take this family exemption, which gives them $3,500 from the estate. Then we get into category 3, which is cost of funeral and burial, and medical costs within 6 months of death. So that's what I was talking about earlier, that when you get the statement of claim from Medicaid, they are going to break it up into 2 categories. So any of the medical expenses within 6 months of the person passing away, they're going to have one line for that. That's going to be a category 3. And then you'll see later on down that they will have the rest of their claim, and that falls into a 5.1. So there are a lot of other things that get paid before that. You know, if we had to pay for a grave marker, if there was back rent due by the decedent, they have to pay that. Then we get to the rest of Medicaid's claim. So in a lot of cases, the entire statement of claim is just not going to be paid. There's usually just not enough money. So this is something that really worries people. I mean, could you imagine, you know, you're trying to administer this estate and you get sent this huge stack of papers and it says that you owe $500,000 to the state of Pennsylvania. It can really put people into a panic. But don't worry, because you only have to use the funds in the estate, and that's the probate estate. You do not have to use your own funds, and you do not even have to use, say, like life insurance proceeds that were directly paid to you as a beneficiary. Those are protected and are not used for part of this. Or if there was, say, like an IRA or something that there was a little bit of money still in and there was a beneficiary on, that's not going to be part of this as long as there was a living beneficiary on it. So now we're going to get into that gifting part that I was talking a little bit about earlier. So I'm sure most people have heard about how you need to be careful with gifting. The problem is that all the different government programs have different gifting rules. So for example, you've probably heard about, oh, you know, my accountant says I can give away, it's now $19,000 per person per year here in 2025, and I will not have to file a gift tax return. That is true. You would not have to file a gift tax return. You will not owe taxes on that, and the person who's receiving it from you will not owe taxes. For the Veterans Administration, if you're trying to apply for benefits with them, they say you cannot make any gifts at all within the 3 years that you're applying for certain benefits through that. Now, the Medicaid rule is that if you have made any gifts within 5 years of the Medicaid application, then you have to report them, and there would be a penalty period for that. So just as a general rule, we typically say that you do not want to give away more than $500 a month, and that's total, that's not per person. So if you have 2 children that you like to gift to, you can only give each of them $250 in 1 month. Or you can give one $500 here in January and the other $500 in February, but you cannot give both of them $500 because that would be $1,000 per month, and that would be over the threshold amount. So something that a lot of people have gotten into this habit of doing is that they'll take large cash withdrawals out from the ATM and they'll, use that to pay all their expenses. Unfortunately, those cash withdrawals, Medicaid is going to assume were gifts, that you gave those away to someone else. So you have to be so careful about that. I will say that we've had some success with using affidavits to explain that no, they weren't gifting it. That's just what they've always done. They've always dealt in cash. And that's how they've always paid for their groceries, their gas, all the things that they normally need. And for the most part, that has been successful. But you need to be so careful about this. You need to stop gifting if you are, and really, really be cautious because it will cause this penalty period. So the way the penalty period works, and I have that divisor there, is that if you give away, let's say you gave away 20,000, let's just keep it simple. We'll say $24,000. Okay. So then that $24,000 is going to be divided into our 12,000 number there. And then Medicaid will come back and say, well, you're applying for Medicaid and we see that you do not have any more money left, but because you gave away this $24,000, we, Medicaid, are not going to pay for you for about 2 months because that's the penalty period. So you will have to pay privately for your care for that amount of time. The issue is that people typically do not find out that they are not going to qualify for Medicaid until they have already been in the nursing home for a while. So they may now already owe the nursing home, say $50,000, and Medicaid saying that they're not going to pay for them. So some nursing homes will and can sue your children to pay for your care. So that's why you have to be so careful about this gifting and making sure that you're not doing anything that would make you ineligible for Medicaid. And that law is called the filial support law, just in case you wanted to look it up. So big question, common question I get, is your home at risk? So while you are living, your home is an exempt asset. So you can, as long as you get your assets down to the other levels, you can own your primary residence, apply for Medicaid, be in the nursing home, and still keep your house. So they are not going to force you to sell it. Now, there are circumstances where people are forced to sell it because your income has to go to the nursing home. So if you don't have your income to pay for the household bills, that's where people get forced to sell it. Now, is your home at risk when you pass away? Yes, it is. So this is something that, people get very confused about because they think, well, I can get on Medicaid and my house is exempt. But now when you pass away, if you owned that house in your name alone, estate recovery is going to make a claim on your estate. And really, when someone's on Medicaid, in those circumstances, their estate is pretty much just their house. So now your house is fair game. It is at risk. So can your heirs still receive your house after you pass? Depending on how large the estate recovery claim is, no, they can't get that because you have to pay back estate recovery first. But of course, there are some exceptions to that. So some things to think about. There is the caregiver exception, the undue hardship waiver, and then just generally, there is this $2,400 estate waiver. So if when you pass away, let's say you do not own your home and all you had was a bank account in your name alone that has, let's say, $2,100 in it. So Medicaid says that they're going to waive any claims against accounts that are worth $2,400 or less. So that's just a general exception, a general waiver that they're not going to take those funds. So let's talk about that caregiver exception. So this is a transfer that would occur while the person is alive. So it allows us to protect that primary residence if a child is living with the person or had been living with the person right before they went into a nursing home. So it has to be a child, and they had to have been living with the Medicaid recipient for at least 2 years before they went into that facility. And then the big thing is that they have to have not only been living there, but they also had to have been providing care at such a level that kept that person home as long as they were home. And that if it were not for that child living there, then they would have had to go to a facility sooner. Now, the issue with this is that you do need to get a doctor to verify this. So there is a specific letter that we send out with factors that the doctor would have to sign off on. And in there, the doctor is saying, yes, this person has been my patient for this amount of years. And if it hadn't been for their child, so-and-so living there, they would have had to go to a facility much sooner. So that's the type of language that we're looking for in that verification letter. So if that is all we have, then we can transfer the house to the caregiving child while the person is alive, and Medicaid is not going to hold it against them as a gift. So they're not going to disqualify them for Medicaid. Now let's talk about transfers after death. So let's say it was a grandchild living with the Medicaid recipient and caring for them. We cannot use the caregiver exception for a grandchild. It had to have been a child. However, we can apply after the person passes away for this undue hardship waiver. So this is saying that, the grandchild, I'm just using grandchild because that's a common one. Grandchild was living with the Medicaid recipient. Medicaid recipient then went into the nursing home. Grandchild had been living with the Medicaid recipient for at least 2 years before they went into that nursing care. They cannot have any other permanent residence. So now when we're applying, they still are living at grandma's house. They have nowhere else to go. They had cared for grandma for at least 2 years before she went in. And they have this magic doctor note that says the same things as before. If it hadn't been for grandchild living there and helping take care of the patient, then the patient could not stay home as long as they did. And you really have to prove a lot for this. Not only do you have to have the doctor verification letter, but you also have to show, that this person truly lived there for this period of time. So they have to show like W-2s, driver's licenses, maybe they're on a utility bill, all things to prove that they were living there that whole time. They've not been anywhere else. They've nowhere else to go. So, kind of a twofold factor qualification that we use there, doctor side and proving they've been living there. Now, you can also get an undue hardship waiver on an income producing asset. So when someone is applying for Medicaid, there are 2 different ways to have real estate be exempt. It's if it's their primary residence, which we talked about, but then also if they have an income producing property that is income that they rely on, Medicaid will also exempt that property. But once the person passes away, it is fair game then. So here is an undue hardship waiver for the income producing property. The one I went over previously was for the primary residence. So for this one, example would be like it's a working farm and everybody is relying on that farm for their income. So it's got to be a spouse, a child, a parent, sibling, or grandchild who can apply for this waiver. It cannot be, the neighbor down the street who's always worked on the farm and has helped me out. It has to be one of these relatives who can apply for this. And you have to prove that the asset was used to generate their primary source of income for the household, and that if they did not have this, they did not have this income source anymore, then their gross family income would fall less than that federal poverty guideline. So you have to be so careful about this. And it can't be, oh, it's just this other rental property that, grandson's been living in and he only pays $200 in rent. We give him a break. That's not going to be income that you're relying on because it's only $200 a month. So I have a couple examples here. So we have John and Sally. John is 75 and Sally is 70. They've been married for 45 years. John was diagnosed with Parkinson's disease and has been in the nursing home and on medical assistance for 5 years. They jointly own their house, which is valued at $300,000 as tenants by entireties. Now, John has passed away before Sally. So Sally is still living in their house. We get a statement of claim and it says $400,000. The only asset, the only thing that John owned was his house that he jointly owned with Sally. Can estate recovery make a claim on their house? So the answer is no, because the estate recovery can only make a claim on John's probate property. So he would have had to have owned the house in his name alone without a beneficiary on it. In this case, he still owned it with his spouse, Sally. Now, Sally would have still gotten a notice from estate recovery. They call it an estate recovery questionnaire. So she would not send in her statement of claim request because there's no probate estate here. But estate recovery would have sent her the questionnaire, and she would have had to prove with the deed to show that she jointly owned the property with John. Second example, same people. So we have John and Sally again. They've been married for 45 years. John has Parkinson's. They jointly own their house valued at $300,000 as tenants by the entireties. Now, in this case, Sally passes away before John. So John is still living. Is estate recovery going to take the house when Sally passes, even though John is still alive? So remember, we talked about estate recovery is only going to recover when John passes away. So they're not going to make a claim when he's still living, even though now the house is in his name alone. Now, next part of the example, John passes away. So even though he originally jointly owned the house with Sally, because she passed away first, he became the sole surviving owner, and now that is going to be his probate property. So that statement of claim for $400,000 is going to be a claim against his estate. And remember, we had said that the house was worth $300,000, so they're going to take the full value of the house then. So they will make that claim. They'll take the full value unless we can do like an undue hardship waiver like we talked about. So I know I've thrown a lot at you. It's 10:45. We'll take some questions. And don't forget to unmute yourself if you have any questions, or I don't know if there was anything in the chat. I'm gonna, oh, and my contact information is right there too if anyone needs it. do see there are some in the chat, so let me take a look at those.
I have a question. I do have my hand raised.
Oh, I'm sorry, I can't see that. Okay.
That's okay. Are you familiar, or is there such thing called a quit claim deed?
A quit claim deed. Yes.
Yes.
So when you're doing a quit claim deed, it's just similar to like a regular deed transfer, really. But depending on when you would do that in this process, it might be considered a gift and would be an issue and disqualify the person for Medicaid. So like they would
I'm
have
sorry.
to do the deed transfer more than 5 years before the person was applying for Medicaid.
Okay, if the person is not applying for Medicaid at all, how would that work?
So if you were, say, like transferring a deed, say to a child, for example, and using
Yes,
a quit
yes.
claim deed, okay. So that kind of goes back to what I was saying earlier about, being careful. If you were to say transfer your house to a child, yes, it may avoid estate recovery. It might affect it, being accountable for Medicaid. But if your child gets sued or divorced, now your house is part of those issues and it's not yours anymore. So it can be a huge issue. Or if, the child's not living there, they can have massive capital gains when they go to sell it in tax. So it's not necessarily something that's like our first go-to. There are other tools that we use. Like I said, trusts sometimes are better to handle that, to protect it.
Okay, thank you.
Sure.
Yeah, I have a
Jessica,
question.
I'm sorry, I wasn't able to unmute myself.
Oh, that's okay.
Did you do the first question? I'm sorry.
No, not yet.
Okay.
I just opened it now.
That's okay. I'll go ahead and start with the first one.
Okay.
And we're going to use the chat feature if you could first, and then anybody else who's not able to use that, we'll do the actual unmute yourself and talk. So the first one I have was a direct question to me, so nobody else could see it. But if there is no probate property, must I submit a statement of claim? I am administrator for a member.
So if there is no probate property, and so you have not actually opened the probate estate, you've not gone through that court process, then no, you do not have to request that statement of claim.
Thank you. So the next question is, does paying college tuition directly to a college on behalf of a grandchild count as a gift within 5 years of a probate event?
So it's not so much, so yes, it does count as a gift, but it's not so much with regard to the probate, but it's more with regard to like a Medicaid application. If you would pay for a grandchild's college, even though you're paying directly to the college, or even if you would transfer a car to a grandchild, these are all gifts that would make you ineligible for Medicaid when you're applying.
And the next question is, it's in relation to the estate recovery. Is it the same if the house is owned by John and child?
So in that last scenario, if John had jointly owned the house with a child and it was joint with right of survivorship, then no, estate recovery could not make a claim against that because there's another surviving joint owner. Remember, estate recovery can only make a claim when the person owns something in their name alone and it does not have a beneficiary on it.
And would that matter, I guess, if the age is, if they're under an age or a particular age?
So for estate recovery, it always has to be, they can only recover if the person was 55 and older.
Okay.
Are you taking questions other than the chat yet?
We have another question here. Thank you for the presentation, was very good and informative. So.
Oh, thank you. Thank you.
Okay, so if if we are done with the chat feature, I don't see any more questions. We'll unmute yourself one at a time if you have a question. So
I have a question.
I have one more online one. I'm sorry.
Okay.
Does the son then die and the state recovery take over?
No. So estate recovery can only make a claim against the person who was receiving Medicaid's probate estate. So if they don't have a probate estate when they pass away, because it all went to son as a joint owner, they can't then get it from son's estate because son was not the Medicaid recipient.
Okay. How do you add a beneficiary to real estate?
So that's kind of the kicker. You really can't. There are things people can do with life estates and remainder interests, but you have to be really careful and make sure it's done correctly, not only for creditor issues, but also for the Medicaid side of it. So certainly that's, something that can be talked about. But, for the most part, using an irrevocable trust would be the best way to protect that. Because then you're adding a beneficiary to it and the trust has become the owner. So it's not even in the picture at all for Medicaid.
Thank you. So that is it. So now we're ready for the live questions. Sorry about that.
Okay. Can I ask you a question?
Sure.
Absolutely.
Yeah. This is about probate and Pennsylvania inheritance tax. My husband passed. I was the sole survivor and I got everything without a problem. I was the beneficiary. Now my will states him as, he as being my beneficiary, but it also says if he's deceased, if he's passed, then it goes to my children. Does that mean I would have to get another will? Well, because it would be up for probate, and how will Pennsylvania inheritance tax, play in that?
So when you pass away, it's not really based off of if you have a will or not, whether you go to probate. It's based off of if you own something in your name alone that does not have a beneficiary on it. That's what determines if you are going to go to probate. It sounds like your will has contingencies in it, so you would not need to update your will. Certainly you would have to take a look at it to be sure. But, if you own something in your name alone, like your house, for example, now, if that's in your name alone and you pass away, it is going to go into probate. Probate is only big, bad, and scary if you have the Medicaid part of it. If you were never on Medicaid, it's not going to be a huge issue.
Thank you.
And then the inheritance tax, just to kind of hit home on that, even if you avoid probate, that does not mean that you're going to avoid the Pennsylvania inheritance tax. So it is 4.5% to children. The only things that avoid that, like I said earlier, would be the life insurance, or, if you have it in a certain type of trust for at least 1 year before you pass. Those are the main ones.
Thank you.
Mm-hmm.
Van Johnson here. Continuing on the inheritance tax. If I would sell my house to one of my children, say for $10, would I avoid the inheritance tax? And can I sell my house of any price? I read somewhere you can sell your house for like $1 if you wanted to a sibling and avoid inheritance tax. Is that true?
So you can transfer it to a child. We always see the $1 transfer, and they didn't actually pay you $1. But you would have to survive that transfer by 1 year in order to avoid the inheritance tax. But like I said earlier, there are a lot of risks with doing that. Like if you just transfer your house to your child and then they get sued or divorced, now you could lose your house, which I've seen happen to people. Or if they die before you, then where does your house go? Because it's going to go through their estate. And then beyond that, like I said, you could have some serious income tax issues with capital gains.
Okay, thank you.
Mhm. I think there's another one in the chat maybe that popped up.
Yep, there was one that popped up. I own a home jointly with my son. Does my share of our jointly owned property get counted as an asset in probate?
So if you jointly own it as with rights of survivorship, then it's not going to go into probate. But if it's jointly owned with tenants in common, then it would. So then it's each half goes through probate. So you'd really have to look at the deed to see how it's owned.
This amazing presentation you did. Well done.
Oh, thank you.
I know PASR has a recording of it and people can listen to it on their website. Is there also a way that a person can request or save this presentation on their computer?
I don't know, Nancy, do you know how? I don't know how you all set it up.
It's going to be
Download
saved on
it.
our website, so it'll be a YouTube video, and so you should be able to watch it as many times as you'd like.
But
I'm
how
not sure if
long
you
would,
can.
how long would that last? Like, is that indefinitely it would be reserved there, or is there a period of time where it will be cut out?
Maybe Samantha can answer this. I'm not sure.
Yeah.
We will keep the video posted on our website, like the link to the video on our website for a full year until the next set of winter Zooms come out. But it will stay on YouTube indefinitely. So as long as you have the link, you'll have access to the video.
Then we just bring what PASR up with YouTube?
Yeah. Yep.
Okay. Thank you.
And call if you need assistance. We're here to help you. So.
But does PASR reserve it on their end indefinitely?
I know
we
that
do.
we have it on our website, like Samantha said, for at least a year. So, but it will be on YouTube, I think, indefinitely.
Okay, all right. Thank you.
You're welcome. Do we have any more questions?
Jessica, can you hear me?
Yes, I can hear you.
Mylene McCollum, this was a wonderful presentation.
Oh,
When
thank
you
you.
speak of giftings and so far as it being non-taxable, what kind of record keeping is needed, if any, on that?
So, the gifting can get very complicated because of all the different rules. If you're only thinking about, gift tax, then as long as you stay under the yearly threshold, which this year is 19,000 per person per year, you really do not have to file anything for that. You can talk with your accountant about that. But like I said, for like Medicaid purposes, you would not want to give away more than 500 a month total.
Okay. Yes, thank you.
Sure.
Now, Van Johnson again. The nursing facility. If a person does go to nursing facility, is that covered completely under Medicaid or does Medicare play in that formula?
Yeah. So when someone is in the hospital, they have to have the 3 overnights. So they switch from observation status to admitted. And then if they're discharged to a nursing facility from there, Medicare is going to pay up to 90 days for that care. Unfortunately, they typically don't pay that full 90 days. Most people are lucky if they'll get 20 days. And then after Medicare stops paying for someone's care there, it's private pay until you've finished doing your spend down or whatever is needed so the person can get Medicaid to pay for the long-term care.
Okay.
Have any more questions? Okay, I guess if we don't have any more questions, I want to thank you, Jessica, for doing this really wonderful, informative
Thank you for
presentation.
having me.
Thank you. And so, as we mentioned, it's going to be available on our website. And if you have questions, concerns, we're here to help. Jessica, as a member of PASR, you can get a free consultation through her and also a discount for her services. So we do thank her for offering that, because it's something everybody can really use. So, and also February 20th, she'll be doing a Social Security presentation, differences between retirement and disability benefits. So if we're done with questions, and I just want to make sure everybody knows that if you're not a member, we would love to have you as a member. And we offer a variety of other discounts as well, including dental and vision benefits, auto, homeowners, Hershey Park. We have something called BetterHelp, which is a newer one where it offers an online counseling service, and many more. And we encourage you to use them, and we encourage you to call us with any questions. So we also have local chapters that you can join, and they get together for luncheons and have they serve their community on a local level. So if you have any questions or concerns, or you don't want to talk over the phone, call us here at PASR at 717-697-7077, and we're happy to speak with you in person and live. So thank you, everybody.
Thank
Thank
you.
you.
Thank you.
Bye-bye.
Bye-bye.
Thank you.